Thank you. Please be seated.
You argue for the defense? Pardon me? You're covering for the defense?
Your Honor, I'm going to start for a few minutes, and then Mr. D'Angelo is going to conclude, if that's okay with the court.
All right, so we are back on the record. Thank you, Mr. Jones.
Thank you, Your Honor. If it would please the court, as I indicated, it's my intention to make some opening remarks, and then with the court's permission, Mr. D'Angelo will conclude our argument.
May I trust you do not object, Mr. Bell?
No, we do not.
Thank you. Judge, as I began the last two arguments that I made to you in this case, I told you that I was mindful that this court understood the facts that were in evidence, and I was certainly mindful that this court understood the law that's applicable to this case. And I would begin again today by saying that same thing. It's not my intention to restate testimony to you, but I would like to highlight some points for the court's consideration. This case is about the law and the facts. And again, I know that this court's aware of the law from the United States Supreme Court to the Ohio Supreme Court in White and all of the cases that you've reviewed in between. And I know that the court's aware that the standard of law that we have here is that what we don't do is 20/20 hindsight. What the United States Supreme Court has told us and what the Ohio Supreme Court has told us is that this is not an exercise in Monday morning quarterbacking. Your Honor, this case is about 2.6 seconds. This case, in part, is about legal justification under Plumoff, White, and Garner. And when I say this case is about 2.6 seconds, Judge, it's because the government's experts and this court, in your Rule 29 opinion, Rule 29A opinion, have taken us to that point. Again, the government's experts and this court. Judge, you wrote back on April 26th, taking the evidence in the light most favorable to the state, at least 34 of Brelo's 49 shots were reasonable to deal with a perceived threat. Same thing our experts said. You said, Judge, if he's eventually found guilty of voluntary manslaughter beyond a reasonable doubt, in the face of his affirmative defense that all of his shots were legally justified, it will mean only that he was not justified in taking one or more of those last 15 shots to confront the perceived threat. Taking the evidence in the light most favorable to the state, a standard that we had back in Rule 29 10 or 11 days ago. We're no longer at that standard, obviously. And I know the court's aware of where we are today. But even taking the evidence in the light most favorable to the government, to the state of Ohio, all 13 shooters that night were justified. 12 of them, in the light most favorable to the state of Ohio, have been ruled completely justified. They've been completely justified by Mr. McGinney when he said he wasn't going to charge any one of them. They've been completely justified by the lack of an indictment coming from the Cuyahoga County grand jury, and they were justified by the state's use of force expert, W. Ken Castaris. Judge, those same folks have, in this court, have placed a legal justification in Officer Brelo, even in the light most favorable to the state of Ohio, for the first 34 shots. When I tell you this case is about 2.6 seconds, Judge, it's because that's the amount of time from the middle shot to the beginning of what has been termed the second series. 2.6 seconds. So we've got a man that's been, Officer Brelo, been ruled legally justified all the way up to the last 2.6 seconds. And I guess the question here is, if he's stripped of that legal justification, not a justification we've got to come in here and prove to you because we're already there, can he be stripped of that legal justification in 2.6 seconds with everything that occurred prior in this incident and everything that continued to occur as this incident went along? Judge, I would like to talk briefly about two areas. The first one is causation. And I know that the court, again in your Rule 29 written motion, cited State versus Powell and the accurate law in Ohio for causation. The cause is an act cause is an act which directly produces the death and without which it would not have occurred. Judge, you heard from three medical examiners in this case, Dr. Weens, Dr. Philo, and Dr. Rowe. And cumulatively and collectively, we learned a lot about each individual wound that was sustained in this case. And there was a lot of questioning about how would you analyze this wound in and of itself. Would you say it's immediately incapacitating? Would you say that it would cause death in this amount of time? Would you say that it would be non-lethal? And we were able to do that with each coroner and go through in a systematic approach. But then what did we learn? That in the short period of time that all of these wounds were sustained, that there was a collective injury that was very important and made it very difficult to determine pre-mortem, post-mortem, perimortem. That any one of those wounds individually could be examined and better opinions could be made as to whether they were pre, post, or perimortem. We learned that while these wounds were numbered in a particular order, that there was actually no way to say, based upon the autopsy itself, in which order these wounds were sustained. Not one of the three coroners could do that for you. Judge, there was a lot of attempt with Dr. Weens and Dr. Philo to give possibilities of angles. And I think I called it twister or contortions of the body that could place the body in such a position that the shooter could have been in any other position. And we did that quite extensively. And I believe that when we were done with the state's medical examiners, only one shot was able to be lined up to a reasonable degree of medical and or scientific certainty by the government's doctors. And that was Dr. Philo with shot number 10 on the passenger. And he told me that he could do that solely because of the A-pillar in the car and the trajectory backwards. But other than that, both Dr. Philo and Dr. Weens told you that there were an infinite number of possibilities, an infinite number of things that may be consistent in and of themselves, but couldn't say anything else to a reasonable degree of medical certainty. Medical examiner Weens actually came down here and we sat in a chair and we talked about the shots 1 and 2 to Russell and the number of different possibilities. And I think that when she was done, she said if the head was bent all the way over or over like this, that could be from a shooter on the hood of the Malibu or the trunk of 238. But she also told you that was just as consistent with coming in through the car from the right. It was just as consistent with coming in through the back. She told you that those were all consistent, but she couldn't tell you that any one of those she could form an opinion based on a reasonable degree of medical certainty. So we've got a whole lot of possible or maybe or couldas, but when the government was done with their medical examiners, we had one shot, number 10, that Dr. Philo could attribute to an angle to a reasonable degree of medical certainty. Your Honor, we then called Dr. Rowe. And who is Dr. Rowe? Well, let's see. She's performed between 6,000 and 7,000 autopsies. She works largely for the government. Probably 95 or 97% of her work has been done for the state of Texas, the state of Minnesota, various medical examiners' offices that work with the police and work with the prosecutors. And she told you that she learned at a very young age, when she was a fellow, much as Dr. Weems was when she performed her examination in this case, well, that when Dr. Rowe was a fellow, she was told it's important to branch out. It's important to have perspective in your practice. So she takes an occasional case and reviews it for the defense. But that's who she is. She's not a paid private consultant. She's a lady that we stayed late for because she had to get back to work and be in Texas performing autopsies that morning. What did she tell us, Judge? She made some opinions that now did come to a reasonable degree of medical and scientific certainty. And what did she tell us? For Williams, shots 1, 2, 8, 11, and 13, to a reasonable degree of medical certainty, could not have come from an elevated position on the trunk of 238 or the hood of the Malibu. And what did she tell us about Mr. Russell? That the shots 1 and 2 and 16B and 16D could not have come from the hood of the Malibu or the trunk of 238 to a reasonable degree of medical certainty. And we went through a lot of these, and I'm not going to reiterate, as I said, or repeat her testimony, but I think what's important there is she can say that, not on a maybe, not on a what's consistent, but on a reasonable degree of medical certainty. And how could she say that? Because she had the parameters of the photograph taken by Aaron O'Donnell where the bodies were found immediately. The photograph that's been displayed for the last month on the Mondo pad and in other pictures over here. And she could look at that positioning, the position of the bodies, not the twister game that I talk about, or if you're standing on your head, you can get a different angle. But this doctor, to a reasonable degree of medical certainty, can look at where the bodies were. She can look at the body of Mr. Russell and see him laying back on the seat and slumped to his right. And what can she tell you? She can tell you the same thing all the coroners agreed with. Shots 1 and 2 went through the spinal cord and were immediately immobilizing. No volitional movement. Not from your pinkies to your toes. You couldn't perform another movement. And what did she tell us? That if he had placed himself in such a position to get those shots from the hood of the Malibu or the trunk of 238, that there is no medical way to be found in the position he was found in. No medical way whatsoever. Dr. Weems tried to give us an aside that, well, perhaps additional shots could have moved the body up and over. Dr. Philo debunked that himself, and even as Dr. Rowe acknowledged, even if that were remotely possible, which we know it's not, there were no such wounds that would have made that movement. Dr. Rowe took you through each one of those. For Williams, 1, 2, 8, 11, and 13. And told you, and she sat up here on the witness stand, and she looked at her charts, and she was asked, could that have come from the hood of the Malibu or the trunk of 238, and still found those bodies in those positions immediately after the shooting? And she did the arrows through her head or through her body. She contorted herself on this witness stand so that she could show you the position that the body would have to be in for that to be consistent, and she could show you why that was not possible to a reasonable degree of medical certainty. And she did that with 1, 2, 16B, and 16D for Mr. Russell. And she went through that exhaustively. And then she was asked for a further opinion. Can you say to a reasonable degree of medical certainty whether or not either of these folks, or both, would have been able to sustain all of their fatal wounds from a shooter from the trunk of 238 or the hood of Malibu? And this question was asked again, not possible, not maybe, but to a reasonable degree of scientific certainty. And she said, no, they couldn't possibly have sustained all their fatal wounds from there. They couldn't have sustained them because you wouldn't expect or have their bodies found in the positions they were. The bodies could not contort themselves into that number of positions in that period of time, and that was not reasonably scientific. Judge Mr. Bell, and I'll compliment him here, he's a excellent lawyer, and he does a fabulous job. He got up and he cross-examined Dr. Rowe into the night, till about 8:30, I think. And as good a lawyer as he is, and as talented a cross-examiner as he is, he said, well, doctor, isn't this possible, or perhaps this is consistent? And some of those points, Dr. Rowe, and I know you remember, she said, no, you can't group those together like that. There's too many wounds. But some of them, she said, well, if you take the parameters of what we're looking at out, then I guess you can say anything you want. And Mr. Bell said, well, can we take the parameters out? The parameters of how the bodies are found. Well, if we take the parameters out, it's not science anymore. And Dr. Rowe said, sure, okay, you're going to remove the parameters. You could probably individually make just about anything you want come true. And again, Mr. Bell artfully, tactfully, skillfully did that well into the night. Judge, on redirect examination, though, Dr. Rowe was asked all of those things that you told Mr. Bell, as skilled a cross-examiner as he is, in order to give these opinions to a reasonable degree of medical certainty, you need the parameters. If you know how the bodies are found, you've got to deal with that. That's a fact. And she was asked, can you say that any of the possibilities or consistencies that Mr. Bell, again, skillfully attempted to have you say, are any of those an opinion that you can hold to a reasonable degree of medical certainty? And she said no. Because you need parameters in that process. She was asked, has anything that's been said in the courtroom all night long changed your opinion as the opinions that you gave to Judge O'Donnell that 1, 2, 8, 11, 13 for Williams, 1, 2, 16B and 16D for Russell, to a reasonable degree of medical certainty, could not have come again from the hood of the Malibu, the trunk of 238. She says, no, nothing's changed. That's my opinion to a reasonable degree of medical certainty. So, Judge, we've got Philo with 1, number 10, on the passenger. And that's the only one the government gave you to a reasonable degree of medical certainty. Now, I will acknowledge, and certainly, Dr. Rowe did give other fatal wounds that were consistent with an elevated shooter on the hood of the Malibu or the trunk of 238. And we went through those. And Mr. Bell went through those as well. But we also, to a reasonable degree of medical certainty, excluded 4 for Mr. Russell and 5 for Miss Williams. Because you need the parameters to have the standard. And Judge, I believe if you apply the causation instruction from Ohio jury instructions and from State versus Powell, along with the scientific evidence in this case, you'll find that the government has not sustained their burden by proof beyond a reasonable doubt on that element. Judge, I'd like to talk about one other witness in this case. A gentleman, I guess it was cross-examination is what you would call the question I had with him, but a gentleman, a police officer, he's been called a rookie, Cleveland police officer Brian Sabola. And when I say I guess formally that was cross-examination, I sure didn't feel like it was. Judge, we were told in an opening statement a month ago that Officer Sabola was the only one that had the courage, I think the fortitude, and I think the word hero might even have been used, to tell you that this was the only man who would come forward and put Cleveland Police Officer Brelo on the hood of that Malibu. Today, he was referred to again as a rookie with moral strength and courage. I'm going to agree completely. Absolutely. You know, the interesting thing, Judge, about rookies, and we've heard about this whole conspiracy or loss of your training or your ability to know what you're supposed to do. The interesting thing about a rookie, or the guy who has the least amount of experience at the scene, is that while he hasn't been on a whole lot of these, he's the closest guy to the academy out there. It's often said a lawyer knows more law the last day of the bar exam than he ever knows again, because you've just studied it. You've just had it drilled into your head. You've just been tested on it. What do we know about Officer Cebulek? What was he doing? What was the probable cause in his mind? We know that he got out of his car. We know he fired shots. We know he came around the car, fired other shots. And then we know he stopped for a moment. But that's where the whole story isn't given to you. Yes, he made a statement to BCI. And yes, he made a statement a Garrity statement in context of the Cleveland Police Department. And what do we know that he said to BCI? Yes, I saw somebody get on the hood of the Malibu. Is that why you stopped shooting? I didn't stop shooting because it was calm. I stopped shooting because I'm getting a better advantage. It wasn't over. And this is back to the 2.6 seconds, Judge. Because if they want to add up those last 15 shots, they got the middle shot, all of their sound people, our sound people, look at that Brelo dash cam, and there's 18 shots. 18. They say 15 of them are Brelo. We've already talked about that. We're legally justified. Our probable cause exists right there. From that middle shot to the next series of shots is 2.6 seconds. 2.6 seconds. When we're in a stressful situation, Judge, we've all done it in this courtroom, this trial, we say, may I have a moment? Can I look at my notes? Can I go over here to confer? What can I do? 2.6 seconds from that middle shot until that last series starts. And what do we know about that last series? Within that last series, there's 3 other shots. There's some guys who said it, our sound guy who said it. There's 3 other shots. Here's what nobody can say. Was there 1, 2, or 3 additional shooters? Well, we know there's at least 1. So we know Brelo's, you heard his statement, he's never been so scared in his life. You know what he said. He continues shooting. That has to be a reload in those 2.6 seconds. There's a continuous thought process of the harm. We know that 1, 2, or 3 other officers also perceived that probable cause because they continue shooting within that series. But what do we also know? Because we can't pick out who they are. They could have been anybody around here. We can't look into their minds. We know they exist by scientific evidence, but we don't know who they are. But whose mind can we look into? The brave guy, the guy with the courage, the guy with the moral strength, the rookie, the guy that just got out of training, the guy who said, if you saw someone on the top of the car, what did it cause you to do? I stopped shooting because I no longer had a clear shot to the threat. Not that the threat was over. During that 2.6 seconds, Cebulek takes himself from a position of cover to move himself to continue to advance to the threat. The guy that just got out of the academy. I'm going to the threat, Judge. I then moved from cover behind the engine block of zone car 232 to the rear zone car 238 so I would have a clear shot. And what else did he say? What else did he say? The hero, and I do not disagree, and by my re-emphasizing that, it is not disrespect, because I have nothing but the utmost respect for Officer Cebulek. I discharged my weapon at the driver because I believed the driver was shooting at me. Mr. D'Angelo is going to talk to you, and we gave you a lot of other experts to give you explanations for why people see things and why people hear things or perceive things and what happened along that whole chase, and I'm stepping out of my area of this argument in doing that. But I do want to talk about Officer Cebulek, because he's the one guy that can come in here who's been, rightfully so, deemed a hero and has courage, and he can tell you what was going through his mind in that 2.6 seconds. And had the probable cause ceased? Was it all calm? Did everybody stop? And he didn't. He didn't. He's the man we heard from, the man that left cover and was advancing to continue to get a clear shot. Judge, I'd ask you, whether it's been some texts or Officer Cebulek in a statement, look at everything. Don't stop where you get part of Cebulek's statement and they say, well, Cebulek stopped shooting because Brelo was on the hood. Well, they stopped their argument there, and they stopped their direct examination of him there. The first time you hear in statements that are given to us by the government, the first time you hear about that is on cross-examination. Anything negative that came out of Cebulek came out through us. And again, I don't consider cross-examination because we merely asked the man, the young officer who told Mr. Gutierrez, you can't train for this, when questioned about his training. You can't possibly do that. The officer that was concerned for his mom, worrying about him, that officer, we didn't cross-examine him. We didn't challenge him. We merely asked him while he stood right here, what were you perceiving when you were here? And what he was perceiving was a continued threat, continued harm, and a need to advance forward from cover. Again, the only other live person that could tell you that right there, advance forward from cover to get a better shot. Well, I'd ask you, as with all of the areas in this case, and I know you will, please consider everything. And with the court's permission, I'll now defer to Mr. D'Angelo.
Thank you, Mr. Johnson.
Thank you, Your Honor.
You're welcome.
May it please the court. Your Honor, the challenge of giving an argument in a case that's lasted 4 weeks, number of witnesses, long hours, is to somehow, in a setting where we've had a judge who's paid careful attention, taken a lot of notes, how do we put all this into an argument to help guide the court in making a determination in this case? So you will not see from me here, although it's always been how I've argued cases, I'm, I guess, what you call old school. I'm not going to show you a PowerPoint or selectively pick out parts of the record. There's no doubt in my mind that you probably, better than anyone in this courtroom, honestly and objectively recall the evidence. We've been operating under a lot different pressure, both sides, and sometimes we see things or hear things the way we want to. But I trust and have faith that you'll get it right in this case, as you have throughout, and as you've demonstrated in your rulings and your demeanor as you've presided over this case. So I want to talk about that night, reality. Not sound bites or trying to spin it a certain way. And in that process, I must confess that I reflect back when I first started as a lawyer. All of us, we had idealistic notions of the career we are about to embark on. And I always remember the Aguilar and the Spinelli case, when the courts talked about the role of a judge in assessing a search warrant on a motion to suppress. And the language that sticks in my mind is that the court acts as a fair and neutral and detached magistrate in assessing whether or not there's probable cause to issue a warrant that complies with the Fourth Amendment. And you've demonstrated in this case that you've had that demeanor and you've discharged your duties along those lines. And in doing so, we give life to the principles that we all learned in civics class of separation of powers and checks and balances. Those are very important concepts. And so as we look at this case and we try to show you the reality as we see it, we appreciate and recognize the beauty of our system that at this point we are finally out of the hands of prosecutors and others for a determination that's made by someone who is independent. Your Honor, reacting and risking one's life is not the same as using illegal force. And I wonder how all the critics, how all the naysayers, from whatever perspectives they may have, how would they view this case if once upon going into the Malibu, investigators found 2 weapons with spent shell casings inside that Malibu? How would we characterize Officer Brelo's actions? Your Honor, although I have differences with some of the conclusions and the testimony of Mr. Casares in this case, from listening to the opening, closing of the prosecution, where they cherry-pick certain things, and as you recall with the Hummel text is the perfect example. And I think cherry-picking is a charitable description of their performance. I'm withholding evidence from you. But I'd like to bring some reality and perspective back to what happened in this case and how the state's own expert characterized what happened, and that we give life to and meaning to the words of the U.S. Supreme Court in all these landmark cases of Garner and Graham and others, that we just don't idly cite 20/20 hindsight and Monday morning quarterbacking and similar type principles, and then cite them and run away from them and act differently. Because I think that's what the state did in this open and close and throughout this case. So in the words of the state's expert, he characterizes what happened in this case as a very complicated police action. He states that the pursuit was reasonably initiated after the reasonable belief that someone in the vehicle fired a gun in the vicinity of the Justice Center. And he further states that adding to the reasonable perception these officers held that it was a gun firing is the addition of 2 other independent witnesses, a security guard, a parking lot attendant, who reported it was their belief that a gun had been discharged. The state's own expert opined that with the initial and reasonable perception that the vehicle fired upon the officers, there was no alternative but to attempt to stop the vehicle. Therefore, the initiation of the pursuit was indeed reasonable. And the state's own expert, who had the benefit of 20/20 hindsight, but who tried to keep within the parameters of the law in describing what had happened, further opined that considering it was reasonable to initiate a pursuit and that the reason was the reasonably perceived deadly force against two police officers when the initial loud bang was reasonably interpreted as gunfire, this was a vehicle that should be pursued aggressively because of the reasonable belief that the occupants presented a real and perceived danger, not only to the initial officers that believed they were shot at, but to other officers and the public if they were to escape. Not my words, Your Honor, their experts' words. Their expert continued to opine that the threat reasonably continued to present as a deadly threat by not only the high speeds of attempt at escape, but by reasonably articulated and specific actions of the driver and passenger, overlaying the fleeing that gave the officers every reason to believe that at every turn, this vehicle and its occupants were preparing for, planning, and attempting to impose deadly force against the officers. Their experts' words, Your Honor, not mine. Their expert, in drawing upon and complementing the investigation that BCI had conducted, continues to opine that, like my own analysis, and I would indicate parenthetically if one were to call it an analysis, but this is closing arguments, so I beg the court's indulgence, because I know the court properly has reminded some of the trial participants in here, in this case myself included, that we need to keep it within the line, so to speak. But in any event, like my own analysis, the thrust was reviewing, documenting, and recreating the use of deadly force perceived reasonably to be used or prepared to be used by the occupants of the fleeing vehicle and that of the Cleveland police officers attempting to neutralize the threats and potential threats of the vehicle's occupants. Each of the officers' descriptions of the decision and perception, even if mistaken, was reason based upon articulated movements, actions, or reasonable beliefs based upon other officers' reasonable perceptions and observations. The real responsibility for Cleveland police officers' involvement resulted from the failure of Russell, the driver, to heed the lawful commands of the numerous officers to stop. Russell's reckless and dangerous driving at speeds up to 100 miles per hour elongated and exacerbated the pursuit. However, the specific body language of both he and Williams, as well as his fleeing, driving, and speeds, lent credibility to the perceived belief that they were dangerous. When the potential of the possible mistaken belief that shots were fired by them at officers was presented by the possible backfiring of their car, it was not a stretch to arrive at the reasonable perception they were indeed shooting at the officers or planning and preparing to shoot at various points during the course of the reckless evading of the officers. The officers did have a reasonable perception of the need for imposing deadly force, even if mistaken. As I believe the court case resolutions and the law clearly state, and is well and expertly presented by Mr. Bogdanoff's report, their expert that they ran from. So, Your Honor, the language of the state's own use of force expert characterized the events that led up to the final shooting at the school. And I ask you if that description rings true with the state's opening, closing argument that you've just heard. I respectfully submit to you that they are markedly different. Your Honor, I believe, and I would like to start with what happened in the parking lot, but you still must be mindful of the collective knowledge that everyone was operating under. So I respectfully direct your attention in your deliberations to the CAD report, which the defense had to introduce in this case, and I respectfully direct your attention to the timeline that was created by BCI so you can get the real-time reaction from various districts and what was actually broadcast that we had to unearth and present to you in this particular case. And when you do that, Your Honor, you'll get the perspective, but not the entire perspective, Your Honor, because we went through that with Agent Soraya. We went through how the agents had to do critical listening and have their headphones on and go back and replay because there was static, there were excited voices. It was, as was demonstrated in court, you could not always hear everything. Some officers may not have heard certain broadcasts. You have that evidence in front of you, and I'm confident that you'll weigh and assess that appropriately. But, Your Honor, there can be no mistake that numerous Cleveland police officers from all walks of life, of different races and gender, interpreted what they were hearing that night as dangerous, and it warranted a response. Now, we fully understand and acknowledge that the Cleveland Police Department does have a pursuit policy. But, Your Honor, I hope you will recall the testimony of Lieutenant Cutts when he reminded us that the Cleveland Police Department, prior to November 29, 2012, did not instruct, did not train on the pursuit policy as part of its in-service training on an annual basis that officers have to go through. It was done in the academy, and that was the end of it. And if you were lucky enough to have a boss who at roll calls would call your attention to the policy, even though the practice, the real world practice of implementing the pursuit policy differed from what was in writing, as Lieutenant Cutts explained. That was the reality. But in spite of all that, you heard testimony about how the pursuit began and why. And I humbly submit to you, Your Honor, that the numerous Cleveland police officers that responded did so out of a sense of duty and a sense of discharging their sworn oaths to serve and protect. And make no mistake about it, Your Honor, in spite of all the recriminations we hear time and time again, there are many in this world who appreciate, not that we're putting them on a pedestal and making them not held accountable to our laws, but many of us know that police officers, men and women, they stand the post and they tell all of us, nothing's going to hurt you, not on my watch. And that's why they responded that night, Your Honor. They responded throughout the streets of the city of Cleveland, and in spite of all the criticisms that have been lodged, and by playing and going through the theatrics of playing that video time and time again, there are many parts of this pursuit that were not high speed, Your Honor. The high speeds were occurring on the freeways. But as it traveled throughout the city, the officers slowed down, they blocked streets, and they did what they had to do. Why? Because they were pursuing two individuals who engaged in the conduct that Mr. Katsaris described as I just read. And, Your Honor, as we'll review shortly, in the Plumoff case, in the Gardner case, in the Graham case, in the White case, references have been made that the decisional law in this country from the U.S. Supreme Court in the Scott case is to the effect that people who are being pursued do not have a right to expect police officers to stop pursuing them. The law is that the officers have a right to pursue and a duty to pursue, even as Mr. Katsaris acknowledged. So we can't rewrite history, and we certainly can't rewrite the law, because the law provides that officers are duty-bound to pursue. And so that's what happened. So when the prosecution likes to poke at the union officials who call this the perfect chase, the context of that was no one was hurt other than what happened at the end. There were no innocent citizens that were driving that got broadsided. And much of that is accounted for because of the officers taking precautions to block off intersections and the like. But many of these officers, Your Honor, responded. And we didn't have the whole parade of them in this particular courtroom, but they're not criminals. Your Honor, these officers have families. They're married. They have children. They responded this night because they wanted to make sure that if anyone else needed help, they would be there to assist. And you know why, Your Honor? Because they work these mean streets. They know what it's like when you're dealing with heartless felons and other criminals that are predators out there in our community. And you never know what you have until it's all over. But they responded in case help was needed. Not because they were in some rodeo and because they wanted to show how they were out of control or how they were above the law. These men and women responded out of a call to duty. And that's the sad and true reality of this case. But they've been held up to ridicule because with 20/20 hindsight, we now know that there was no weapon found in that vehicle. And now the lens that everyone looks through the facts of this case indeed are quite different. But that didn't stop BCI from concluding that you cannot infer that they did not have a gun or they did not have a gun because of the positive gunshot residue tests that were found, and because no weapon was found, one cannot infer that they didn't get rid of it. So the truth is that we'll never know unless you have the ability to divine back in time what really happened. Was there really a gun in that car that they successfully threw out after a shot was fired? We'll never know. But we do know, Your Honor, that they were smoking crack after this incident occurred as they were driving through the city. And we do know that Mr. Russell, he's above the law because he's done this in other jurisdictions. So the police, don't mean anything. Just look at that screen, Your Honor, and look at all those police cars with lights and siren. And yet, the man never stopped the car. I think that any trained police officer would have a heightened sense of concern that this individual really must be a bad person when he continues to flee with all this show of manpower. And the same individual, Your Honor, who was characterized as being wrong and the cause of this, not the Cleveland police officers, but Mr. Russell was the one that went through Happy's Pizza, went up on the sidewalk in his effort to get out. He drove his car constantly, and any police officer would reasonably believe that this was not the end of it. He demonstrated for over 20 minutes, Your Honor, that he would keep going, as now all criminals know in this town, that they have a license to keep fleeing because the police are not allowed to pursue them. But there was nothing stopping him until he used his car as a deadly weapon and until the officers felt that they were being shot at by the occupants of the Malibu, Your Honor. That's the cold, stark truth and the reality of what was reasonably perceived on the night in question because of the actions of Mr. Russell and, yes, Miss Williams. The state has tried to sharpshoot selected portions of radio dispatch tapes and put in Officer Brelo's mind, just him, all this knowledge about whoever was behind him. As the court's ruling on the Rule 29 motion sets forth, there were 17.8 seconds where this gunfire erupted. Even Officer Bartzek, who testified, the officer from Bratnell with the dash cam, the reality of the moment when he was there, Your Honor, there was no pause. He perceived it as one continuous sequence of events. Just like Fairchild testified, there was no pause, it was one sequence of events. Just like Hummel testified, it was one sequence of events. They didn't understand from listening to the tapes after the fact that there was a slight, and I do underscore the word slight, pause. And Officer Sobolik, Your Honor, he also testified that he did not detect a pause. It was one sequence of events. And Hummel, Fairchild, and Sobolik did not hear anyone yelling ceasefire. And we'll talk about the significance of that when we review the Court of Appeals decision in the White case, Your Honor, when Mr. Katsaris in that case made reference to the issues of light and sirens that we get ridiculed for making reference to in this particular case, like it was not a problem out there to hear anything. It was not a problem to see everything crystal clear, even though bullets were flying. So, Your Honor, when Mr. Russell pulls into the lot after leading the police on this high-speed chase and comes back into this area and turns around, we have tire tracks on this island and we have skid marks. And again, I'm reminded as I come by here of Mr. Katsaris' testimony and the questions I asked. Your Honor, some people may think I'm a smart aleck or as Mr. McGinney says, it's my stock and trade. I always attack people. People that know me know that that's not the case. But I will fight for a client to my last breath. But the fact in this particular case, Your Honor, is that Mr. Katsaris didn't know if he was in Honolulu or this middle school parking lot. I asked him about a supermarket being back here or a fire department being back here, when we all know it's a school, because it's dawned on me that from reading his report, he goes from Officer Brelo getting out of 217 to getting behind 238, and his report then goes that the next actions were he's on top of the Malibu. He never talks about being on the trunk of 238. And I think that's significant because no expert with all his abilities could ever forget that Brelo was on 238. If he bothered to look, there were smudges and footprints on the trunk of 238. There were smudges and footprints on the roof of 238, Your Honor. And that just conveniently is not in his report. And Brelo goes from the rear of 238 up onto the Malibu. I respectfully submit to you, Your Honor, that he did a cursory review in the 3 weeks that he had the case, and he was relying on Bogdanoff to do all the heavy lifting. Though only one of those two that testified in the grand jury, not Mr. Katsaris. And they didn't call Bogdanoff. But the fact of the matter is, Your Honor, that he did not thoroughly look at this case because he would have known that there was no fire station here, there was no supermarket here. He couldn't even tell you where Diaz was in the overall scheme of things, and other officers. And when they tried that method with Dr. Rowe, when Mr. Bell was just going to show her x-rays after watching what I did with Katsaris, see if he can trick her up because maybe they didn't like what she had to say, she said him straight, didn't she, Your Honor? She knew that one of those drivers had a broken arm, and she caught that as she was looking at the x-rays. I submit to you that that's important in this particular case. When a person comes into court and he doesn't even make reference to Brelo being on the trunk of 238, you know why it's important, Your Honor? Because they like the fact that they want to now argue, because of what they did in March of 2014, that Brelo fired from the trunk of 238, gunshot wound number 10 on Miss Williams. They want to try to make that one of the illegal shots. So in order to do that, because now they had Martini's report from us, and they know we didn't run from Officer Brelo's use of force in this case. We confronted it, and we went to experts to try to explain it. We didn't hide in this case, Your Honor, and take a position. No one can say with reasonable medical certainty or scientific certainty where these shots came from, which in essence is the testimony from the coroners in this case, other than shot number 10. We went to experts, and we didn't selectively ask them, just tell us about the headshots and the other fatal shots that didn't come from the elevated shooting position on the Malibu or 238. We asked them to look at it and tell us, good, bad, or indifferent, what's your opinion here? And they shared that with us. We shared it with the state. So, Mr. Katsaris, Your Honor, did not look at everything, and he did not say anything about Brelo being on 238. And the state now is trying to use that and back and fill themselves into a better situation. You know, when that was happening, even though we're in a justice center, Your Honor, unless you can feel it up there, the ground was moving in this particular courtroom when they did that. Because they pivoted and they changed part of their theory of the case because they wanted to capture some shots from the trunk of 238 and recall all the pleadings that they filed in this case, how they kept on talking about the last 15 shots. The last 15 shots. So now they're trying to go beyond that to get more shots because they now realize there may be an issue about causation in this case. That's the reason for the pivot. That's euphemistic. I call it being dishonest. And I also call it dishonest, Your Honor, when they march into court and they selectively play or selectively present to you as a finder of fact, as a judge, they withhold the text from Officer Hummel where he stated that they definitely had a gun. That was his very first text that he made on that subject matter. They were thinking and hoping that we were lazy and we wouldn't have read through the 198 pages of rumor mongering and gossiping that you find on all those text messages. But we found it. And even though it was 8 o'clock at night and we were all weary, we presented that to you, Your Honor. We didn't lie to you about it or try to withhold that from you. So, in this particular analysis with Mr. Katsaris, we know that Mr. Russell came over this island, there's tire tracks here, and there's skid marks on the curb. And Officer Diaz was right there. We have his shell casings. And he, in fact, fired those first 4 shots, Your Honor. And he, in fact, when they talk about close range and all that, he struck Mr. Russell. He hit him with 15B right in his heart. And he hit him with 15D. And that's the opinion of Mr. Martini. And they wanted it into evidence for some reason. We may hear it in their close, about why they wanted Martini's report into evidence. But the report they wanted into evidence has not only Dr. Rowe confirming that those gunshots came from Diaz, but also has Dr. Posey's opinion that's referenced by Mr. Martini, that 15B and D came from Officer Diaz. And that's consistent with the mannequins. When you look at the mannequins, Your Honor, you'll see the yellow rod coming in this trajectory. We went through this when I examined the witnesses. You see the officer, I thought he was up on the grass. Mr. Martini says, no, his feet were on the asphalt, but because of the elevation, that accounted for the trajectory there. So, as Dr. Rowe testified, and I think one of the state's medical examiners testified, that shot, he was still capable of driving the car. So as he drove by here, and again, I'll get to it later, but unfortunately, we haven't heard from all the officers in this case. But that's not of our making or creation. But the fact of the matter is that Mr. Russell drove his car here, almost hitting other officers, and got into this position where he almost ran over Sistek, hit 238, and all the gunfire started. And that's when Brelo responded, Your Honor. 17.8 seconds, take the 4 off from DS, so 135 gunshots at that point, in that limited period of time. That's the reality that these officers had to deal with. That's the reality of this case, Your Honor. And, maybe I am a smart aleck when I talk about they're experts and, well, when you were listening to the audio, was someone shooting at you or was there gunfire going on? Obviously the answer is no, that wasn't happening. But look at all the measures that they get to take, all the efforts to try to slice and dice and try to come up with an opinion in this particular case about how many gunshots were fired, how many seconds, how many milliseconds. Well, they're doing all that, Your Honor, and there's no gunshots whizzing by their head. But we made fun of the Cleveland police as gunshots were going by their head that they reasonably perceived to be coming from the occupants of that Malibu. And also Mr. Casares co-signs that those shots were coming from that Malibu. So, what are we to do? I was waiting, Your Honor, on the edge of my chair to when am I going to hear about this training? When is the state going to present evidence? All this training that the Cleveland police go through. They introduce a use of force policy, a pursuit policy, and they put up Mr. Casares, hey, conceal and cover. Well, Your Honor, when we were in elementary school, we all learned about the certain basic instincts. To procreate the race, you have to eat. But also it's self-preservation. What's the big training about conceal and cover? Like we're paying an expert to come into court and tell us about a basic instinct that we all have and that we all learned about in elementary school? Where do we have any testimony, Your Honor, about the simulations of shoot and don't shoot and what officers go through? Did they ever present anything that would help you understand what is this training that Officer Brelo is throwing away, that he's disregarding, that makes him such a bad guy and the culprit for everything that happened here? Zip. Nothing, Your Honor. Not one bit of testimony, no evidence whatsoever on what's this training that these officers get. And even with that, Your Honor, if they had presented testimony or evidence on training, according to decisional law from the Sixth Circuit, every other federal circuit, and the U.S. Supreme Court, training is not relevant to a determination that an officer committed a crime. Training is not relevant to the determination that an officer used excessive force. You have to look at the facts and circumstances of the case. We cited the Freeland case, which was in Mr. Bogdanov's expert report, and which is in all the other case decisions that are referenced here. The Freeland court held that Sixth Circuit, it is not proof and not relevant to proof of a constitutional violation of someone's rights under the Fourth Amendment to be free from excessive, unreasonable force. It is not relevant in that determination whether or not a pursuit policy was violated. In fact, motions in limine are always filed in the 1983 litigation, Your Honor, to keep these matters out because the courts have held that we want cities, or if a city wants to have a higher threshold that officers must meet, fine, but we don't want to deter them and impose liability on cities or officers by saying that, well, because you violated that high level, that high threshold, you now are culpable in this 1983 litigation. So again, in spite of all the recriminations in this case, all the pursuit claim violations, that we had more than 2 cars, that you didn't go on the air and get permission, all that, and besides Brelo committing the crime of getting off of his feet, it's not consequential in the constitutional jurisprudence in this area, period. It's very simple. But yet they want to make much of that. So, again, Your Honor, look at the reality of what happened there. Look at the horror. I recall that you looked in the compartment of one of those police cars out there on scene when we were at the that warehouse, what the heck is called, the loading docks. And I was struck how narrow the seating is. So can you imagine being in there and the horror and the terror that you would have in shooting through the windshield when your partner's shooting as well? And what impact does that have on your sensibilities, on your ability to hear? What's going through one's mind when one's firing a gun through a windshield? What would cause a kid from St. Raphael's and St. Ed's who served our country in the military, who has a family, what would make him want to shoot through the windshield at another human being? Could it be that he was being shot at? Could it be that he reasonably perceived that the occupants of the Malibu were shooting at him? That's what all the other officers perceived. That's what Officer Brelo perceived, Your Honor. And there was nothing that the occupants of that vehicle did to dissuade them from that cruel reality that night. So Officer Brelo fires, he gets out of his vehicle, he gets behind 238. They want to say that he's calculating, okay, I got to save my gun jammed because therefore I have less bullets I fired, so therefore I won't have any trouble in this case because, I fired too many times. And is that what we're to believe? All the other officers misjudged. There's time perceptions, time distortions rather. They all misperceived how many shots that they fired. They all misperceived how long this took. So he gets behind 238, he continues to fire, and again, I'll never forget Mr. Gutierrez here, wanting it both ways. Well, the car, the Malibu, it's lodged in the, 230, it can't move. Well, Brelo, even in his statement, indicated that he thought that there was a little more distance, and also he didn't perceive that. Who in their right mind would have been able to perceive that with gunshots going by their head, Your Honor, in the dark? That this vehicle was somehow disabled. That wasn't anyone's perception. And so if you're behind 238 and you make an instant decision to jump onto the trunk because you were worried, terrified that the occupants here who ran like hell for 20 minutes would still try to get away and gun it and try to get through. And then as Mr. Gutierrez talked about, then he changed the facts because now he was criticizing the conclusion that he didn't want to get trapped under 238. So now he's going to make it you can't be trapped there because he was going to accelerate and go right through. So they want it both ways. They want it to be disabled, but then they want to criticize Brelo for saying he jumped on 238 because, if you would have been trapped, he still could have gone through and hit the car. They wanted every which way, but the reality of the experience, Your Honor, is that when the gunshots are flying under nighttime conditions, with all of these sirens going, with all of these lights flashing, the reality is that that's the last thing in your mind. You're reacting, you're trying to save your life. And that's what he was doing. And anything else you've heard in this courtroom, Your Honor, is 20/20 hindsight.
May I ask you to pause for a moment?
Yes.
Do you have a rough estimate of how much longer you got?
Your Honor, I haven't practiced this, so I have no idea.
Who's doing the final close, Mr. Bell?
Yes, sir.
You are?
Myself.
Do you have a rough estimate?
I think I might be about 40 minutes, Your Honor, maybe a little bit longer, depending on what else Mr. D'Angelo has to say. At this moment, probably
Judge,
about 40.
I would need more than 15 or 20 minutes with my client.
Why don't we do this? I hate to interrupt your closing argument. On the other hand, you want your closing argument to be attended to. So not only do I need a break, I think we probably all do.
Including me, Your Honor.
So why don't we resume on the record with your closing argument right at 1 o'clock? Does anybody object to that?
No, Your Honor, there'll be no other court business during this time, correct?
No. Is that okay, Rob? Is that enough? What time did you say? Right at 1 o'clock, 40 minutes. Okay, so we'll resume on the record at 1. Thank you.